I'm Liz McGill, the Dean of the Law School at Stanford, and I'm just delighted to welcome all of you here for what I think Mark and Bill just told me is the 5th conference in this series, and we're just extremely happy to have you. I want to especially thank Billy and WilmerHale for their generous support of today's conference, as well as the Stanford Program on Law, Science, and Technology, which is the driving force behind this conference at the law school. I know all of you in this room know that the law is not known for its rapid response time, but in a world of biotech, it's forced to keep pace. As a result, intellectual property in the biosciences area is one of the most dynamic and innovative corners in the legal world. And the people in this room are some of the finest minds in the field, from our own Mark Lemley, who I think may have published an important, highly influential article by the end of the first session today, to Lisa Wallette, who is also new on our faculty, and her cutting-edge work on innovation benefits a lot from her PhD in physics, to Christina Smolk on loan from the engineering school, and WilmerHale's Bill Lee and Robert Galvin, an amazing lineup of folks. We're especially honored to welcome and host a lineup of esteemed federal judges for our first panel, which is going to provide a view of the current state of patent litigation in the biosciences before we dive into some of the more specific discussions. One of the great benefits of Stanford Law School's location is its proximity to scientists and technologists who are reinventing their fields. The law school tries to take as much advantage of this as possible through conferences like this, unique multidisciplinary approaches to issues in intellectual property and innovation law. We do that conferences like this, the Law, Science, and Technology program, our Intellectual Property and Innovation Clinic, and many more efforts. We also benefit from proximity to a multitude of amazing practitioners who are very generous with their time and their ideas. And speaking of the generosity of all of you who've gathered, I'm going to stop now and turn it over to Mark Lemley. But I'm so happy to have you here. I hope it's a very productive conference, and I suspect it will be.
And I, in turn, am going to turn it directly over to Bill Lee, who's going to run our first panel. Thank you, Dean. Why don't we have the judges come forward for the first panel?
I wonder why. You're all reverse.
Somebody had to make it go co-ed.
Yeah, we need someone to say be seated. So let me add my thanks to all of you for joining us today. This is the 5th time we've done this over 10 years, and every year has been interesting and energizing, and we hope you'll find it to be the same today. The first panel is going to be focused on patent litigation in the federal courts, not so much focusing on biosciences, as I promised the panel, but looking at patent litigation and what's going on more broadly today. We have a terrific panel of judges who I'll introduce briefly, but it includes Judge Gajarsa from the Court of Appeals for the Federal Circuit, but also among the district court judges, judges from the districts that have some of the most important and the largest patent dockets in the country, districts who have decided some of the most critically important cases, and districts that have helped develop the law of procedure and substance in the patent litigation area. And I've had the privilege of having tried cases to several people on the bench, won some, lost some, but always got a very fair trial and a great audience. So if I start on my immediate left, and I'm going to do brief introductions, we could take the whole hour and 15 minutes with the introductions if we did that, but that's not what you want to hear. So let me start with Judge Gajarsa, who's immediately to my left, who is now senior counsel with us, but he is formerly a judge of the Court of Appeals for the Federal Circuit. He actually started his career as a patent examiner. He also served as special counsel to the Commission of Indian Affairs. He was in private practice and represented many of the Eastern Indian tribes. He had one hair-raising moment when he was litigating a case and arrived back at his car only to find the windshield having been blown out by people who didn't agree with his position. He decided that would be a good time to become a judge. He was nominated in 1997 to the Federal Circuit by President Clinton and served 15 years before he stepped down. To his left is one of his former clerks, who has gone on to much greater things, although Paul said he was looking forward to having this opportunity to engage with Judge Gajarsa here. But Judge Grewal, as many of you know, is a magistrate judge in the United States District Court for the Northern District of California. He, before becoming a judge, he was Judge Gajarsa's clerk. He was a trial lawyer who tried patent cases in many of the jurisdictions that are the busiest: East Texas, Delaware, the Northern District of California. Since he was appointed to the bench, he has tried cases, handled some of the most significant procedural and substantive matters, and has been a real pioneer in addressing one of the issues we're going to talk about today, which is how do we get opportunities for younger lawyers in the courtroom. His left is Judge Guilford from the Central District of California. Before becoming a judge, he was a partner at Shepard Mullen, where he did a wide variety of cases in the business and commercial area. He also was the president of the State Bar of California and the Orange County Bar Association. Since his appointment in 2006, he has sat by designation both at the Federal Circuit and the Ninth Circuit. He also is in the patent pilot program, as are several of the other folks, and we'll ask about their experiences in the program. To his left is Judge Hochberg. It's getting harder to look down, but I can see her now, who was formerly both the United States Attorney for the District of New Jersey and also a United States District Court judge. She recently stepped down and has gone into the world of mediating, arbitrating, and actually helping people strategize about how to present cases to her colleagues who are still on the bench. While sitting in New Jersey, she presided over a host of patent cases, particularly in the life sciences field, where she presided over some of the really major Hatch-Waxman cases, and she was in the pilot program as well. To her left is Judge Illston from the United States District Court for the Northern District of California. She was, before she was appointed, a terrific trial lawyer, one of the youngest folks who ever become a member of the American College of Trial Lawyers. She practiced in a firm that did commercial litigation, but had an enormous reputation in the securities field in particular. She was appointed in 1995. I think I tried one of her first patent cases to her way back in 1995. But since that time, she's had a whole series of patent cases, a whole series of really high-profile cases. So she had the Balco steroids case, she had the Barry Bonds case, and she had the multi-district price-fixing case involving LCD manufacturers. To her left is Judge Selna from the Central District of California, who had been an antitrust practitioner before he was appointed to the bench. He served in the California Superior Court in Orange County for 4 years, and then was appointed to the Central District in 2003. He sits in Santa Ana, and he too has had a whole series of high-profile cases, including the Toyota motor cases, which I think you've all read about, that involve 200 economic loss class actions and 170 personal injury cases. He also is in the pilot program and has had a number of complex patent cases, including the Broadcom-Qualcomm wars, which were in his courtroom repeatedly. To his left is Judge Sleet, certainly not last but not least from one of the most active districts in the country, the District of Delaware. He too, like Judge Hochberg, served as the U.S. Attorney, being appointed to be the U.S. Attorney at the age of 43. He was confirmed to become a district court judge in 1998 and served as the chief judge in Delaware from 2007 to 2014. He has had, as a result of his time in Delaware, some of the most important patent cases. He has presided over 92 trials, I think it's about the right number, close to 100, and 92 civil trials and about 32 criminal trials, so he has enormous trial experience. And also now is teaching, passing on his knowledge to folks at Duke and Widener Law School. So it's a terrific panel. I think you can see that they have enormous experience and expertise. And so I'm going to ask a series of questions to just have them answer them. We'll try to do that for 45 minutes or so, but we'll want to allow time for you to ask questions as well. So if you have them, keep them, and we'll be sure that we have time to ask them. So let me just pose this question, and anybody can answer. We haven't assigned questions to folks, so this is going to happen as it happens. One of the questions that folks often ask is, does oral argument help you to evaluate the merits of a party's argument? Does it help you to reach your decision? We'll ask the district court judges first and the former Court of Appeals judge second. Anybody want to go?
Sure. So if oral argument is focused not just on repeating what's in the briefs, I think you can safely assume that most district judges, if not all, know what's in your papers, and they will have read in advance, and probably, if it's a significant motion, for example, either a seriously motion to dismiss that's serious and very substantive, or a motion for summary judgment or something like that, they'll know what you have, what your arguments are on both sides. They will probably have questions, and one of the things that I found most helpful was for me to jump in early with questions and focus it that way. I think the least helpful is when people just kind of read from their PowerPoints. And the worst answer you can possibly give when a judge asks a question is, I'm getting to that 3 slides from now. So it's perfectly okay to say, well, I'm going to answer it now, Judge, and then you'll see 3 slides from now I have a little more to say about it. But it's fine if you want to put it up. The slide deck itself is useful for the law clerks. They keep them, and it kind of serves as an outline for the thinking later on. But at oral argument, you should make eye contact with the judge and really have an interactive discussion, because the judge will ask you what they're really concerned about.
Well, I agree with Faith. I have found that it's helpful to tell the lawyers at the beginning of argument what I'm thinking, because I have read their briefs, and I do usually have a tentative view, and oral argument can be very helpful, either underscoring that or dislodging that if the counsel focus then on the issues that have seemed dispositive to me. So I find it very helpful, particularly in cases where there are open areas that you're just not sure about. In terms of doing it, in my view, the best oral argument is conversational, not oratorical. You want to engage the judge, so if you can do that and get the attention and get the back and forth going, then you're really accomplishing something. And always be honest. Don't ever, ever, ever lie, because judges gossip, and we will talk about that, and answer the questions.
So picking up on what Judge Illston just said, be conversational. Don't write out your speech, your oral argument that you want to make. I frequently see that. I can't see the paper, but it's evident from the eyes being fixed down on the podium rather than on me, trying to persuade me as a human being and you as an advocate on a particular point of view, and being so locked into a narrative that when the judge does interrupt, especially with Judge Hochberg, it was always the case, the bench was hot. I'm teasing, she's my good friend. But if you have a judge who's inquisitive, who really wants to know and benefit from your argument, and you can't answer the question because you're locked into a narrative, you're going to the noise is going to build up in your head, you're going to lose your place, and you're not going to be effective.
I think oral argument is tremendously helpful when you have some thoughts, but you need to crystallize them. Unfortunately, oral argument is becoming a dying art in some districts, with judges taking most, if not all, of their matters under submission on the papers. I frankly enjoy engaging with the lawyers, having them spin out the arguments, make the fine distinctions. I also think ultimately it's an intellectual safety net. They get an opportunity to point out things you might not have seen.
I agree with everything that's been said. We hear talk about the vanishing trial. I'm very concerned about the vanishing trial, but more and more I'm concerned about the vanishing oral argument. I think there is something to be said about lawyers coming together in a courtroom with the judge and engaging in advocacy. I think it's best for you to consider it to be oral discussion, not oral argument. That goes along with what we've heard here about being engaging and conversational. For example, don't come in and say, Judge, I think you got the Smith versus Jones case wrong. Don't say that in front of 50 people. I might be spending the next 20 minutes convincing you and them that I got it right. Instead say, Judge, I'm concerned about your application of Smith versus Jones in light of these other concerns. And then we engage in a discussion. That's a skill that too often is lacking. So think of it as oral discussion. Also, maybe like a scientist, I come out with some notions, and like a scientist, I like to test those notions. Form a theory, test it. And I test it by asking tough questions to the side that I think is winning. That is my way of testing the theories. So if you're getting tough questions, that might be a good sign that you're winning.
Before I offer my 2 cents, I have to just confess that I'm so tempted to take a selfie up here with this group of people. I can only imagine what it would do to my social media numbers.
Where's your selfie stick?
I left the stick in the car. As far as oral argument goes, I certainly hope it is helpful and frankly productive, because I hold oral argument in pretty much every case where I have a motion before me, whether it's a summary judgment motion, a Markman, or frankly the smallest discovery dispute. And why the reason why I find oral argument to be tremendously important is really twofold. One, as a magistrate judge, I'm responsible not only for the cases that are assigned to me for all purposes with the consent of the parties, but also a substantial number of cases on referral from district judges. And typically these are discovery disputes that have been assigned. Those disputes tend to be very factual in nature, and I find it much more effective to engage in the record and figure out where in the record the information is that I need to know by asking lots of questions. So that's why I tend to hold oral argument pretty much in every situation. The other reason why I think oral argument is important, I think, follows from what some of my colleagues here have said already, which is so many cases now are decided by motion. So few cases go to trial at all. It seems to me to be an important element of due process, frankly, to give parties, not necessarily the lawyers, because lawyers are there to do a job, but the parties who I think have an expectation of having their day in court, the chance to come to court, to feel like they've been heard literally by the judge and not merely figuratively. So that's why I think oral argument continues to be an important part of our process.
If I could, before I ask Judge Gajarsa about an oral argument at the Federal Circuit, if I could ask one follow-up question. Judge Illston mentioned a tentative conclusion or decision as she came onto the bench. I know that Judge Selna, you have used tentatives actually in written form extensively. It would be great if you could talk about that process and what you think it does for the oral argument.
Well, I think it helps focus the oral argument. By tentative, I mean a full-blown draft decision. It's published to the internet on my webpage on Friday afternoon. We have oral argument Monday afternoon. So the lawyers have a chance to digest the draft, to know where I'm coming from. It eliminates any canned discussion. People get right down to the issues that are on point. I think it sharpens the oral argument, and it ultimately, I think, results in a better decision. It creates one unique problem that in the dynamic that people have touched on. You know going in, if you're losing, you have to stand up and tell the judge why he or she is wrong. And there's really an art to do that, and some people do it more effectively than others. I always trust that people remember that judges are human and have feelings. But it's a dynamic that isn't present just in a cold oral argument where you don't know where the court is coming from.
I'm just like Judge Selna. I do a complete ruling order. I like to say to my appellate court friends, every Monday, 5 to 15 opinions of 5 to 15 pages in length, and we get it done by noon and start for the next Monday. And sometimes maybe we self-congratulate ourselves that we do that. Until my daughter, a young associate at Latham & Watkins, said, "Dad, you think you're so hot? What you're doing is destroying weekends for young associates at large law firms." I am a little concerned about that. I don't quite know how to fix it, but they do go out on Friday. It's important to read them, and frankly, it means I've got a lot of eyes proofreading my text and finding errors in my text, which is exactly what I want them to do.
So Judge Gajarsa, arguing at the Federal Circuit, you don't have to respond to Judge Guilford on the number of opinions. That's for another day. But in arguing to the Federal Circuit, do the same rules of the road apply or different rules?
It's about the same, because one of the aspects that you have to keep in mind is when you reach the Federal Circuit as the appellant versus the appellee, if you're the appellant, you have a very, very hard road to go up against stream, because most likely the affirmance rate at the Federal Circuit, contrary to popular opinion, is closer to 70–80%. So the reversal rate is somewhat smaller than people talk about. But one of the important aspects of arguing before the Federal Circuit is knowing that the judges on that panel have read the briefs, they know the appendix very, very well, and you should not present your case by repeating the arguments that are in the brief. What you really should be doing is expanding upon one or two issues, because 15 minutes goes by very, very quickly. It's surprising how that red light comes on almost immediately during your oral argument. But it's important to realize that the judges know the record, and you should know the record as well as they do, and better. You also should know that the questions that they ask, hypothetical and otherwise, are to answer some of the issues that they consider to be somewhat nebulous, somewhat gray, and the hypotheticals that they pose to the counsel are more the attempt to define some of the parameters of the issues that are presented to the court. So if you select one or two items that you want to express and expand upon, that's the way to approach oral argument. As Judge Guilford also pointed out, it should be a dialogue with the bench. It's almost like sitting across a dining room table and talking to your partner across the table. And that's the way oral argument should be approached. From that perspective, the need to expand upon the issues, you can be assured that the issues are very well outlined if you've done a good job in your briefs, and the court knows those particular issues and what they're looking for. If you're asking for reversal, remand, or otherwise as the appellant, you've got to be able to also understand what the standard review is, and that's your biggest ally in any argument that you have. And you also should point that out as the appellee from the other side. So from that perspective, oral argument should not be approached to repeat the arguments that you have made in your briefs, because the judges already know those arguments, but trying to expand upon them and covering some of the gray areas that you might have, and select one or two issues to present, and not more than that.
And for those of you who might be wondering about the statistics, the reason that Judge Gajarsa's statistic is correct, but the reason it might be higher than the affirmance rate that you've heard is some of the statistics don't include the Rule 36 summary affirmances. And if you include them, the affirmance rate's much higher. And the number of summary affirmances has increased substantially in the last 4 or 5 years. Now, for another day, there's a debate as to whether that's a good thing or a bad thing. Judge Guilford would say they could write opinions and address them, even if it ruined a couple weekends. But that's the reason for the numbers. If you include the Rule 36 affirmances, it's a much higher affirmance rate.
Okay, I was just going to jump in with one comment. Having sat by designation with them, I can tell you they really do not discuss the merits of the case ahead of the oral argument with each other. It's really, each judge thoroughly prepares on his or her own. And I felt like the newbie geek because I was so well prepared. It was a very heavy I think 6 Markmans in a row. And I had notebooks and outlines of my outlines. And I felt like, you know, I was really wearing the Geek Squad helmet when I went up there sheepishly with my notebooks and my outlines, only to arrive on the bench, and the 2 Circa judges that I was sitting with had equally large notebooks and annotations and outlines. So everybody is super prepared and open-minded, and they don't know how everybody else is coming out until the conference after.
Many times, in order to follow up on that, the judges do not discuss the cases beforehand, and you get to understand what their position is essentially during oral argument. And sometimes the questions are asked of counsel, it's almost like a ricochet shot to the other judges.
Yes.
Very similar to what happens in the Supreme Court. So from that perspective, if you get a question that seems odd to you, it's not really odd. It's a question that they want answered, but they want it answered by the other members of the panel.
And part of that is sometimes the question is a softball for you to hit over the fence and let me prevail, in my view. One of the most amusing things is when I toss a softball and they think it's a high, hard one, and they argue, and no, that was an easy question.
So building on something that Judge Guilford mentioned is the vanishing trial, the vanishing oral argument. One of the issues has been, what can we do to get younger lawyers on their feet, comfortable making arguments so that 25 years from now, the problem is not exacerbated? I know, Judge Grewal, that you have done some things. I know that some others have. So let me broadly ask the question, what can we as a system do to provide opportunities for them? And then secondly, for the panel, what advice would you give to the lawyer today who's 3 years out of law school, 4 years out of law school, who is standing up on their feet for the first time?
I just read a great opinion, a page and a half, that you wrote on getting young lawyers involved, right? Was that recent? And your remedy was your waiving argument? Tell us about that.
Well, the long and the short of it is that, as I mentioned, I offer oral argument in just about every contested motion situation. So getting oral argument time in my courtroom is not usually a problem. In larger cases, like the patent and IP cases that many in this room are very familiar with, I have noticed a substantial trend that senior people are spending a lot more time on issues before me than I certainly remember when I was younger in practice. I see a lot of very senior partners arguing a lot of very early discovery motions, and from there it builds. And so on occasion I have suggested, I've never required it, but I've suggested to parties that they consider allowing their associates to argue a part of a motion or one of 6 or 7 motions on the calendar for the morning. And of course, the senior partners are welcome to participate and come, and if they feel they need to be there as a backstop, I don't have a problem with that. And of course, I can understand that some clients may be reluctant to pay for a more junior person to participate in that way. It just seems to me that courts can play a helpful role in making clear to each of those constituencies that from the judge's perspective, this is not a bad thing. It's a good thing to see new people involved.
My patent local rules specifically encourages it. It certainly doesn't require it. And my patent local rules are partly written towards in-house counsel. I think the big problem is if you're a partner in a firm, to convince the in-house counsel that a younger attorney can take the case. So you can just show them my local rules and say that crazy Judge Guilford likes young people, so do it. There's the interesting phenomena that often in patent litigation, the more senior guy or gal has a soft major. They're an English major or a history major, and the real technology comes from the associate that knows the technology with the PhD in physics. And so there's often the embarrassing phenomenon of the older guy who's very competent, or gal, but majored in history and is turning to the younger person for the technological support, and maybe that can be avoided by just letting them come up and handle the case from the start. One of the problems is when the argument starts to fail or the examination starts to fail. I've sometimes seen bright young associates do the direct examination with perfection, and then wily opposing counsel on cross-examination starts to go where the young associate never thought it might go. And in those situations, I've made it clear I'll let the more senior guy or gal jump in, double team, and rescue a young associate when things start to go south. So I encourage young associates, and I reduce the risk by having the opportunity of an older person to rescue them, against the rule that usually it's one lawyer per issue or hearing or examination.
Let me add something to that, Bill. You and I were talking about this last night, and you were commenting on looking for opportunities as for your associates and younger lawyers to get in there and get in the mix. I mentioned to you Morgan Chu's approach that I've observed when he's tried in front of me a couple of times, really making a liberal use of the younger lawyers. He sort of sits in the middle and sort of directs traffic. And he provides in that way a comfort level to the youngsters and an important source of advice, as Judge Guilford suggests, perhaps if something begins to go south. He's there. So there are these opportunities, but this isn't moot court. This is major league stuff, and it's judges. I think we have to be careful about what we say and do with lawyers and partners, and trying to nudge them to get the younger lawyers involved. Their client is paying some heavy freight to win. This is not, as I said, a moot court exercise. This is not law school. Okay, you're in the United States, in my instance, district court, and you're there for a reason. And if you've gotten to trial, which is increasingly unusual these days, you're there because you think you've got a case and you need to win that case. So I just caution that we've got to be a little careful as jurists about sticking our noses in. And I know I did this, I learned by way of an experience where a partner in a major American patent law firm hadn't tried as a first seat a case, as a first chair, a jury trial. And he sent over some younger lawyers to do the final pretrial conference, and they were excellent. And I called him up and I said, so-and-so, why don't you let them try the case? And he said, Judge, I haven't tried a case yet. And then so I felt like a smack behind. And it was just an example of just needing to tread a little lightly on that subject.
I will say that some judges, Barbara Lynn, for example, in Dallas, does allow, I think, 10 extra minutes for a Markman hearing if a lawyer with fewer than 10 years' experience is doing it. So she's doing some active inducement sorts of things. But on a somewhat related note, I do think the teams have gotten so large that sometimes the focus is lost, and I think that there's a lack of editing. Too much division of responsibility, and sometimes one member of the team doesn't necessarily fully know what the other ones are doing. That is not helpful when that happens. I would encourage slightly smaller teams where everyone knows what's going on, and when you file something, don't just do a sort of virtual equivalent of a mail merge and send the judge everything that every team member has done to get, putting it together without somebody going through it to take out that which is redundant or unnecessary. And I have a war story. In a 30-hour bench trial on a Hatch-Waxman case, I asked for draft findings of fact and conclusions of law in advance. I got 800 pages. My law clerk by then knew that when something like that happened to come and see me before plowing into them. But know that if you get a new judge or a new law clerk, they may spend a week reading them before telling the judge that it's 800 pages. So I said, no, don't read them. I'm just going to enter a one-paragraph order which said there were no arbitrary page limits. There was no arbitrary number of findings of fact and conclusions of law. The only requirement is that either the lead counsel or second chair actually read and edit what is submitted. And I got back 49 pages. So, it's a public resource of time, and it doesn't help to just sort of say, well, we can always correct it later, whether it's draft findings of fact or a final pretrial order. If it gets so cumbersome that it's not useful, then it really is time for someone to kind of really be the leader.
There's a lot of thought now that we need pretrial reform. The federal civil procedure were just amended, as I'm sure you all know. I think much of the problem we're now having is that people don't get to court and they don't try cases. I think pretrial work would become much better if people actually saw how trial works. I once facetiously said we should have a rule that you cannot propound an interrogatory until you have read an interrogatory to a jury. And that would teach you what's important and what's not important. So part of this is a systemic hope that by getting younger people more involved in court with judges, with juries, some of the concerns we have about pretrial expense and wasted time might disappear.
So let me move.
I had a judge from the D.C. Circuit back in the 60s when I was there tell me that a legal document should not be 200 pages, should not be 50 pages. His position was that a legal document should be long enough to cover the subject and short enough to keep the interest. If you keep that rule in mind, you can avoid 800 pages of fact-finding altogether. But that's a rule that I've tried to inculcate into my law clerks and into my opinions, because if you write an opinion that's longer than 25 pages, there's a lot of dicta in it. And you don't need that in any opinion.
There is a great Judge Paul Barbadaro from the District of New Hampshire who tells about the advice he gives young lawyers, and it was the advice given by then Assistant Attorney General David Souter to him. And it was, here are the 3 rules for you as a young lawyer. Be prepared, be yourself, be decent. And if you can only be one of the 3, be decent. Right? He's right. So let me move to a different topic, which actually I'm going to tell the panel wasn't actually quite on the series of questions I sent around. But a lot of the Hatch-Waxman cases have been jury waived, but as we move into the biosimilars world, there is a likelihood that more of these cases will be decided to juries. So I think folks in the audience would be very interested in your experience with the juries, both picking them, but also in many of your jurisdictions, I know Judge Sleet talks to them after they've rendered a verdict. I'm from Massachusetts. You're basically not allowed to talk to them before. You're not allowed to talk to them after, and you're not allowed to even get within 100 miles of them. But other jurisdictions allow much more information. So if I could open up just the question of, do you talk to juries after your verdicts? What have you learned about how they view these complex patent cases? And does that affect how you go about the jury selection process?
I do. I speak to every single jury. I invite them. I say it's voluntary. They all come in because they want to see a judge's chambers. They're all curious. And by the time a trial is over, they kind of feel that they know you and your team. The law clerks love it because it gives them a chance to hear from jurors. I kind of police the interaction to make sure that nothing gets into the deliberative process, but I ask open-ended questions to let them talk and say their perceptions of the process, the lawyers, things about the case, surprises, anything that they were, that they were unprepared for or thought unusual. And it's really remarkable. I guess the takeaways would be that my gut sense is that after about 36 to 48 hours, they bond with each other and support each other, even though they come from enormously varied backgrounds. Some have no education and some have advanced degrees, but they all support each other and they defend each other. If anybody feels a fellow juror is being in any way denigrated, they will rise to their defense. Related to that, they cannot stand xenophobic arguments. There's almost always someone on the jury that's from another country, and even those whose forebears may have come over on the Mayflower get offended if a fellow juror is slighted. So some of the arguments, like Made in America, if it's presented the wrong way, will actually turn off a jury, not turn them on. They somehow, I think, and I've been on panels where none of the judges have talked about any kind of questions in advance, and every single judge who's tried jury patent cases says the same thing so far, which is, it's remarkable, but we all have found that the jury somehow managed to understand very complex stuff. And you really realize that when you talk to them afterwards. They almost never go off the rails completely. And they somehow, there's a group dynamic at work where they understand that there's someone that understands everything. So there may be someone that gets the regression analysis and the chemistry, and someone else that has very good instincts about who's a baloney artist. And they will, as a group, respect each other. And I think, in general, I've rarely had a judge voice a different view, even though they come from all different parts of the country.
In Delaware, we also don't allow the lawyers to meet with we follow the Supreme Court's rule, Delaware Supreme Court's rule. So I go back to the jury deliberation area with my clerks and my staff after every verdict, and that has two goals in mind. The first is to thank the jurors for the difficult duty we've asked them to do, taking them away from their lives and oftentimes grappling with very, very difficult subject matter, and in the instance of criminal cases, also very difficult subject matter. The big takeaway for me is consistent with what Faith has just said, and that is they really do wrestle, even with the most complex material, and make every earnest effort to master the facts you've asked them to find, to really think about what it is that the lawyers have asked them to do and what I've asked them to do. And this highlights for me how very, very important the final instructions are. And inevitably, they will pick up that large packet of final jury instructions in the instance of patent cases and talk about how important it was to their understanding. And so that tells me that the time I invest with the lawyers in trying to figure out how to instruct the jury and in resolving those disputes, as some of you know, I'm sure, those are some of the most hotly contested areas leading to trial. That is, what are the final instructions going to look like? Usually the preliminary instructions are pretty easily put to bed. So that's the big takeaway, or those are the takeaways from me.
I guess
One other thing, I'm sorry. I do invite the lawyers to wait around. It's tough when you've lost a verdict to do that. I get that. You want to get the heck on that train or plane and get the hell on out of Delaware. I get that. But if you want to learn something about your case and how you interacted with the jury, I have my law clerk, the one assigned with me, who's out on the bench, on the lower bench in my instance with me, take notes of the discussion. Now, we don't reveal any confidences or any. It's all constructive feedback that we try to give. But since I'm getting old and can't remember anything, my law clerk will take down notes, and I'll go back and share that. And usually the lawyers wait, winning and the losing side, because they want to know. They're good professionals and they want to know.
I'm on the other side of the spectrum. I don't talk to the jurors after a trial, but I encourage them to talk to the lawyers and the parties and to tell them what went well, what didn't go so well. Obviously, I tell them if anybody bothers you and you don't want it, you get back to me or my clerk. I'd make one comment about juries in general. I think they have a tremendous capacity to learn that is enhanced by effective advocacy. And I'm reminded of a patent case I tried maybe 5 or 6 years ago that involved the technology in read-write heads for disk drives. The technology won the Nobel Prize the fall before we went to trial. The parties had one demonstrative that illustrated the various levels of various metals that were involved in this, and the key to it was the purple layer at the bottom. By the end of the trial, you'd refer to the purple layer and all the jurors would nod. Jurors are very educable, and they really benefit from creative advocacy and an effective demonstrative like that.
Well, I agree, and Faith was saying she felt that most judges would agree with her on her assessment of the jury outcome, and I do entirely. I participated in a conference last week of the International Bar Association, which is a group of international lawyers who do a lot of different kinds of work, including IP work. And of course, they're just flabbergasted that in the United States we entrust such important questions to jurors, to lay jurors. But it is a remarkable thing to watch these folks start out as people who don't know each other at all, and then over the course of the days or weeks to become a jury in the case. And they do try enormously hard. They have pretty good group judgment, and I've been surprised by how good how consistent the outcomes seem to me to be with what I would expect the outcome to be. I allow lawyers to speak with jurors afterwards. I think if the jurors want to. It's entirely up to them, but it certainly can help the lawyers to understand their craft better. I don't talk to them about, pardon me, substance, but I do go back and thank them and ask them if there's any questions they had, not about the case, but just about the process. And that question sometimes is, why do they repeat their same question over and over so much in trial? So that's the single complaint I ever hear is wasting my time asking the same thing over and over again. Do they think we weren't listening? Because they are listening.
They also hate long sidebars because you put a white noise machine on so they don't hear it, and essentially it's like leaving them out of the conversation. So minimize sidebars if you can.
I always invite them into my chambers. I bat about 950 on that. Once in a while, someone will have to get to work or something, but they almost always want to come back. I control the conversation so we don't go where we shouldn't go. The conversation almost always reconfirms my faith in the jury trial system. It's amazing to hear how they come together and get the job done successfully, and 8 or 12 people will find a movement towards the mean and towards the truth, and almost always I'm impressed with the process they have gone through. I answer questions where appropriate. Number one question, you're right, it's why did it take so long? Why did they repeat the question? Number two question is, what is Rule 403 of Federal Rules of Evidence? So I always get to explain that to them, and I appreciate the process.
I've never had a jury ask me about 403, so maybe that says something about my view of Rule 403. I talk to my juries every time. The only thing I'll add to what my colleagues have said is this. They have shared some pretty important feedback that I'd like to share with you all. First and foremost, I have yet to have a jury in any trial I've done, patent, copyright, or otherwise, not reduce the entire case to either a single piece of paper or a single board, a whiteboard on my wall. And so if your jury is in that reductionist mindset as they think through the issues and render a verdict, I would suggest that perhaps lawyers and judges, frankly, adopt that same mindset preparing the case for trial. The second piece of feedback I get consistently, which follows, I think, from some of the comments that we've heard earlier, deposition videos, right? Boo. I understand why you have to present witness testimony in that form from time to time, but jury after jury complains to me that while 30 seconds or 2 minutes of video might have been understandable, 20 minutes or 100 minutes of video back to back to back just kills them, The third piece of feedback I get over and over again is that juries are watching you every second you're in the courtroom. You are on display. It is not merely a place of advocacy, it's a place of theater. And while form should never dominate substance, I do think that some of that is lost when lawyers get stressed, and understandably so. These are not mock exercises, Judge Sleet says. This is the real deal. But when you are on display in front of the 8 or 12 people who are going to be deciding your case, I think it's important to be mindful that every gesture, every interaction with a colleague, every direction to a staff member is under a microscope. It could completely elevate or destroy your credibility without you even knowing it.
So every eye roll should not happen. And most judges now have trials on the clock, which has a wonderful way of reducing, because you burn through it when you read deposition testimony or show the video. It all counts. So it forces the editing process. And most lawyers in advance say, I can't possibly do it in that amount of time. And at the end say, you know what, Judge? I presented a better case because of it.
By the way, I also let lawyers talk to the jurors if they wish, but I always read the rule of evidence that restricts any information that they can get from such conversations?
On the issue of juries bonding, I recently tried a case where it was a 2-week case, but on the 7th day of trial, the jurors started all showing up in the same color outfits, right? The same color clothes. And then they did it the second day, and our client said to me, "What does it mean?" I said, "It means it's really good or it's really bad." There's going to be unanimity, and the verdict's going to be quick.
Paul, can I just ask you to share your story about?
Well, apropos of what
Yeah.
Bill had just said, I think it was about the final Monday of a 2 or 3 week trial I had, my jury started showing up in Giants jerseys. And so we had essentially an entire lineup, from number 1 to number 9 in the entire row. It was pretty remarkable.
Jurors bond.
They do, they bond fast. It's really remarkable. It's like being a freshman in college, and it's a completely new experience, and you tend to bond with the people that you are thrust in with almost at random. And it's a very strong and tight bond, and while they may have tried to get out of jury duty, by the time they're into it, they're really into it.
In jury selection, the attorney might have selected an athletics fan amongst them all, but
It's always amazing
regretted
from
it.
the appellate point of view how juries can come up with the right answer 99% of the time, whether they do it by looking at it as a one sentence or one exhibit, but they always seem to come up with the right answer. It's a good system that we have in this country. The other aspect is that a jury verdict at the appellate level is very difficult to overcome.
Yes.
So that's one aspect that you should always keep in mind. If you do have a jury verdict which is positive, you should look at it from a perspective of an affirmance if you're the appellee.
I would echo that. I think that where there's a choice between bench or jury, you need to think about what the record looks like going up, because it is very, very different. Obviously, in a bench case, there's a huge transparency. You can see every sort of level of analysis done by the judge, but a jury verdict is very different.
So let me ask about a couple of specific developments. For those of you who have had Markman hearings post-Teva Sandoz, has it changed anything? Has it changed how you look at things? Have it changed the evidence that you take? Has it changed the way you look at the task?
I think, Bill, you might like it to change.
I'm working. I'm working.
No, for me, as you all know, Bill, in my Markman practice, it's essentially really does devolve itself down to a question of law. There's inevitably fact-finding, subsidiary fact-finding, I think, of some type that goes on in every Markman question, but probably not enough to get you into Teva world. So as colleagues up on this bench, we probably all do it differently. I know Judge Chesler, your former colleague in Jersey, almost routinely has expert testimony in his Markman cases, according to what he's told me. I don't do that. I don't invite extrinsic evidence absent being convinced that I need to hear it to do my job. And so for me, my world's not going to change a lot.
So I asked the parties in advance whether they feel that they need to or want to actually put in experts and why. In other words, explain to me why it's necessary, and I'll be guided by you. I may not consider it, but if you feel it's that important, tell me why, and I may well allow it. I may not. It really depends. I mean, obviously, we're now all aware of the sort of roadmap on how these decisions are to be reached and abide by them. So the one thing I don't like is I don't want to be told to rely on an expert declaration. If they want an expert, I want that expert to be cross-examined. Too often the declarations are written by counsel. Some of the times at trial, by the way, the experts say something completely different from their declaration, and when they're cross-examined and shown the declaration, they'll blurt out, well, I didn't write that. So you should see whether it's a jury trial or a bench trial. I mean, I can keep a pretty good poker face, but the jury just looks astonished. And it's like a killer right then and there. So while lawyers, especially patent lawyers, tend to think that they want the expert to be the mouthpiece for what they want to say, you've really got to let pick an expert, and then the expert's got to say what he or she wants to say. You can be the scrivener, but it's really got to be their opinion, or it's useless.
My sense is that TEV has made a greater impact in the academic world than it has among practitioners. I can't really see lawyers going at the Markman process any differently in terms of what they've submitted. More importantly, in terms of asking for specific findings. A number in the academic world thought that you get extensive proposed findings of fact to support your legal conclusions. I just haven't experienced that.
I agree with Jim. The sampling still might be too small to be statistically significant, but I don't see any changes. I suspect there might be some changes in the dynamics of settlement, with the district court Markman conclusion being more certain than it was before, which may help promote settlement more frequently, but I've seen no changes.
I've always, since the cases, I've asked the parties at our initial case management conferences, do you want to handle things differently on account of this? Because I don't normally take evidence at Markman hearings, and I give them that option, and nothing has changed so far.
As someone who conducts a fair number of settlement conferences as part of my role as a magistrate judge, I can report I have tried to make the argument that perhaps the claim construction ought to be given deference in light of what the Federal Circuit is supposed to do with fact-finding down below. I haven't gotten anywhere with that argument, so.
I agree with that, Paul. I mean, I'm now outside mediating, and you would I tried to then hammer home that the Markman decision's been made, and what it portends, and eventually I can get some reality to sink in, but it's easier to do that as an outside mediator than it is as a sitting judge, because you always stay clear of kind of foreshadowing the outcome, and I'm not constrained by that anymore.
There was one question I wanted to ask on juries, so I'm going to exercise the prerogative of the moderator and go back. But do any of you allow jurors to ask questions? And if so, how? And if so, what's the craziest question you've got?
I'll start, because I have a sort of a half-assed policy on this. I don't tell jurors that they may ask questions. But if someone says they have a question, I say, fine, just write it down, give it to me, I'll hand it to the lawyers, and then we'll do that out of the presence of the jury, and the lawyers, for the most part, can decide when and how to respond to the question. So they can, but I don't encourage it. I don't say anything about it in advance, because I'm concerned that if they know they can ask questions, then somebody asks a question, so somebody else figures, well, I better ask a question too, and you can get this competition going of people wanting to ask questions. So I do allow it, and we do answer them, but I don't say that in advance. The best question I ever got goes back to something we were discussing earlier, which is mugging and eye rolling, and this is theater, and jurors are watching you. We had a case, it involved some environmental protesters, so it was kind of high profile, and lots of lawyers on either side. And the plaintiff team, of course, always sits next to the jury on the jury side of the courtroom. And there was this one plaintiff lawyer who tended to roll his eyes. So time goes by, and eventually I get a question from the jury, and it's a written question, and it says, Judge, we know that you instructed us at the beginning of the trial that we were to decide the case based on the facts and the evidence, and not on any likes or dislikes, and not because of what we thought of the lawyers. And we're concerned because we think we're getting biased against the parties on account of this lawyer who keeps rolling his eyes. What do we do? So that tells you they really do watch you. So then, of course, it was kind of complicated to explain to the lawyers what the jury had said. But that guy stopped rolling his eyes pretty quick.
I am probably at the far end of the spectrum in that I also invite jurors to ask questions. I actually encourage them to ask questions and have drawn many, many questions in almost every patent or IP trial that I've done. My thinking along those lines is, number one, the Ninth Circuit, where I happen to sit, has specific guidance and rules rules in place to limit and constrain some of the potential risks that have been identified. The other thing is I think it gives the juries a real stake in the process and a place in the process. It's a rather unnatural exercise, right, to tell 8 to 12 strangers that they're going to be spending the next 2 to 3 weeks in this, what in my case anyway, is a cramped little courtroom in San Jose. And they're not to say anything to each other about the case. They're not to ask questions. They are to smile and listen. I find that a bit unnatural and also ultimately counterproductive, because if they have questions, I would think as a trial lawyer, you'd be desperate for that type of feedback in real time to allow you to course correct. As far as the most interesting question I've received as part of that process, in one trial I had a few years ago, the jury at one point during the damages expert testimony asked me whether they were constrained in awarding damages by the limits offered by the plaintiff's damages expert. And I could just see the shoulder slump on the other side of the room. Curiously enough, it was a defense verdict in the end, but you never quite know how that will all play out.
I had that experience in a case where the plaintiff's lawyer was a real mugger. He mugged at everything. The jury is out, sends back a question right before lunch. Can we give the plaintiff what she's asked for or what we really think she deserves? The lawyer and the client go out of the courtroom high-fiving one another. They come back after lunch. First question, was the doctor negligent? Yes. Was the negligence approximate cause of injury? No.
My patent local rules encourages procedures, modern procedures, perhaps the biggest of which is allowing jurors to ask questions. I'm a little concerned remembering law school days and the gunner in the first row of my law school class who could sometimes, kidnap the discussion and take it where it might not go. There are gunners on juries who want to show off and want to strut their stuff, and I'd hate to have the entire trial hijacked just because one juror was asking questions to show off.
How often does that happen?
It doesn't happen that often, but I'm still concerned about it. Maybe your law school class was better than mine. Alex Kaczynski was in my law school class. Love him to death, but I'm a little cautious about that. But you're right. I'm probably overly cautious about that.
He's not going to make it onto a jury. So let me go to a slightly different topic. I know one of the issues that many of the people in the audience discuss or think about is the whole IPR process. And the question I have for you is, has it affected the manner in which you address cases? Is it sort of just a parallel proceeding that's irrelevant to what you do, or has it complicated your lives? Maybe the answer is we don't know.
It has dragged our lives out.
Yeah, I guess I've spoken a lot about this. I think we're still waiting to see whether, what I have always advised and did is that you really need to, the big issue is whether you stay or you don't stay. And in order to do that, you need to look down the road and say, if I stay, what's likely to come back to me? And how likely is it? And what will the shape be? Will I end up with having to have an evidentiary hearing on the scope of an estoppel and real party and interest so that I have 2 trials essentially instead of 1? Or is it likely that the major claims have been instituted? Nobody ever stays until there's an institution. But if so the question then is, and it's not even worth making the motion until there's you can write a letter saying we've initiated, but there's no point, I don't think, even moving until there's an institution of an IPR. And then it's, what have they instituted? Because they're only instituting on 1 or 2 claims, and they're never all the claims in the case. The question is, how central are they? In terms of settlement, it is a good time to, if there's a parallel proceeding that's been instituted, it does have an effect on settlement. I often am now mediating cases where there's both an IPR instituted and a district court case, and that dynamic is certainly fertile ground for settlement. Some people want to settle before the IPR is decided. Sometimes both sides do, especially if they're going to do some kind of cross-licensing deal, and they don't want the patent necessarily to fall. So there are reasons and motivations, that it makes it a much more complex game theory kind of analysis at the settlement stage once there's been an institution. Sometimes, once I have another case where one side says, look, the ones they've instituted on are not central to the patent that we have most dollars attached to. So they basically dropped that from the district court case and are now proceeding only on the ones where there's not been an institution, and so that one's ripe to settle again. So they take all forms. It just adds a layer of interesting complexity. I think too many district judges are too ready to stay without thinking about what's coming back, but it's too soon to tell how much of a tidal wave will come back, because there's, in other words, how many, I've asked this question and gotten varied answers. If they only institute on one or two claims, is it likely that even if those, depending on what happens with those claims, that everyone will settle after the IPR and you won't get anything back to the district court? The worst thing is getting something back that's older, staler, and more complicated and requires more evidentiary hearings on the things that the PTAB didn't go into. Right. But if you really think that none of that will actually ever materialize, then it might be a reason to stay. So you basically ask the parties to do a forecast of what's the likely future.
I'd be really interested to know the practitioner's experience, and that might help inform what I do, what's actually going on. I hear it's an entirely different practice. Is that?
Yeah, I think the fair answer is it's an entirely different practice. As we know from the Supreme Court last week, there's different claim interpretation rules. There's evidence, but not in the same way. I also think, from a practitioner's point of view, I think that, the statistics are like all statistics. They've swung way out to one side, and they're going to swing back in. But to go to what Judge Hochberg said, I sort of look down the road, and you think about, in simple cases, you could kill a patent or not kill a patent and end the case. And in some sense, the rules of the road are designed for that. You could imagine in complex cases where you're not going to kill the entire goose, and I could see district courts having to come back and have to have an evidentiary hearing on what the scope of the estoppel is, which then puts probably a jury waive trial in front of each of you before you can have a jury trial. And it's going to add a level of complexity.
I agree. I don't think and it won't achieve the outcome Congress wanted of faster, cheaper at all. If you actually, I think, and look at the metrics, let's say 3 years from now, how long some of these cases took when they started in the district court, then they get stayed, then they go to the PTAB, then they go to appeal, and then they come back to district court, and then they continue on to trial. It's going to be longer, slower, and much more expensive for those that come back. And the only question is, how many have that dynamic and how many don't?
And I think, Judge Sleet, to go to your question, I think as you look at it as a practitioner, there was a huge series of patents who went through, which were the patents that the AIA probably was intended to cover,
Yes.
and a number of them got killed. But then people got probably overly encouraged, and
Right.
some complicated technologies and complicated problems started to move through, and they didn't get instituted. And for folks in this audience who will be talking about biosimilars later, when the biosimilar litigation it started now, but it's like you're just getting the hint of what's coming. What's coming
Right.
is like a tsunami, and when it arrives, validity is the issue. It's going to be the issue, and it's going to be litigated in both places, and they won't be the simple cases. And I think the complexities in those circumstances are not things that people really anticipate.
I agree, and I think that especially, for example, in Hatch-Waxman, which has its own internal policy considerations where there's a policy balancing within that statute, including the 30-month stay, or up to 30-month stay, all the balancing that goes on, which, you could do a whole program just on that. But I think the biosimilars is just kind of at the beginning of that procedural dance that we went through 11 years ago on Hatch-Waxman, and what comes first. And I mean, I remember when we enacted our local rules on Hatch-Waxman and treated the defendant as the plaintiff. I mean, we got a letter from, we published our rules, and one of the comments was that requiring, the invalidity and infringement contentions, treating the defendant as the plaintiff and going first was like a violation of the Magna Carta principles. And of course now it's just taken for granted. Of course that's what you do, but And I think in biosimilars, while it doesn't have the same statute, right now, everybody's fixated on the procedural dance that's going on and interpretation of parts of that statute that really don't have anything to do with the patent and everything to do with procedure and who gets to do what first and what it means. But the tsunami's coming of the substantive and the IPRs and how the IPRs dovetail in with the particular specialized statutes that apply in the pharma area is uncharted terrain right now.
Well, that's one of the unintended consequences of the AIA. Have any of the judges handled the balancing act between the Hatch-Waxman requirements of 30 months and the requirements under the IPRs?
I think that, I mean, that's a question that's now coming up at the PTAB, I think. In terms of the stay issue, I think district judges are still doing the same, handling the district court case the same way they did. I don't think they would ever extend the stay beyond the 30 months. I mean, because it's all part of the process built into that statute. In other words, the idea being that all of the R&D that the pioneering company goes through gets rewarded in the sense that if an Orange Book listing attacks them, they get up to 30 months, up to either the ruling by the district court or 30 months, where they can continue, where there can't be marketed, the generic can't be marketed, and nothing in that statute requires them to disgorge that 30 months because it's all part of the policy. If the generic gets to piggyback on all the R&D done by the other side, then that's the built-in statutory legislative policy in that statute. So it's substantive policy set by Congress in that statute.
There is no real guidance in that area
Right.
right now,
Right.
because it just integrates the two statutes, but they're not integrated.
They're not integratable, I know, and so we're going to have to do that. I mean, I've scratched my head when I saw it bothered me that the early IPRs were done by short sellers.
Yeah.
I mean, that was really troublesome to me. If I were at the PTAB, I would be coming down hammer and tongs on that. I just don't think it's right.
So I would switch gears to one last topic and then open up the floor to questions. But some of the judges are participating in the patent pilot program or have. Any returns on it? Is it achieving what we want? Is it something that's necessary, unnecessary? Any reactions?
I think it's worked in our district. 6 judges are in the program out of 28 active judges, and the 6 of us have somewhere around 60% of all the cases in the district. It's concentrated the cases, it's given us more experience, and we've had a chance to share best practices among ourselves. So I think it's working in our district.
My view is going to be a little controversial among my colleagues. My pilot patent. I'm not a proponent, and I have been very vocal about my opposition to the patent pilot project. I think when the founders set up our system, they contemplated generalist judges in courts, and my experience from day one, more than 18 years ago now as a district judge, was that the patent litigators were very decidedly the squeaky wheels on my docket. And they've now squeaked enough, and it's not just the litigators, obviously, it's industry, it's inventors, it's all kinds of constituents that we now have the patent pilot project. It may be that I, from my little perch in Delaware, where we are our own, or have been at least, our own patent pilot court, we did not volunteer or raise our hands to do that. No additional resources that I'm aware of, though I hear a rumor that there are some additional resources that have been provided. That wasn't the initial offering as I understood it, but we wouldn't have taken it anyway. So I'm decidedly not in favor. We don't have ERISA courts. We don't have antitrust courts. We don't have securities courts. We don't need patent pilot programs, in my view.
We have bankruptcy courts.
Well, yeah.
And I'd like to talk to you afterwards. He's a Met fan, I'm a Dodger fan. We'll talk about that, and we'll talk about what you're saying here, because I do aspire to fulfill the design of Article 3. I do think it helps me. It helps me get enough patent cases that increases my comfort level with them. When I first became a judge and I'd read Markman briefs, I always concluded if I didn't understand them, it was me. Now that I've read many through the program, sometimes I can conclude that it might not be me, it might be them, or it might be bad arguments. I'm able to more fastly identify bad and good arguments the more Markmans I review. There is also the tension about specialized courts, and I do appreciate your support for Article III general jurisdiction. I've kind of viewed the patent pilot program as an innocent inroad into the broad notion of Article III. We have to make sure it's not the camel's nose under the tent that ultimately destroys general jurisdiction, like all the rest of the world does. But for now, I think it is a modest accommodation to those who want some form of specialization.
Well, just a quick response, because I know, Bill, you want to move on, but letting the innocent decidedly in quotes, Congress stick their nose in the purview of U.S. court jurisdiction, I think is dangerous. We see some of the things that have been put on the books in the interest of trying to regulate non-practicing entities and some of the bills that have been proposed. Judge Selna can probably speak on this as an antitrust practitioner before he came on. I don't think there's a more difficult area, in my experience, to manage than an antitrust case. Yet when, and I've tried a case or two, antitrust case or two, I felt initially at sea, but I had really good lawyers, as we are blessed to have, and so frequently in United States courts, good lawyers who help us understand and help juries and help us as jurists understand the subject matter. I don't think it requires specialization other than the specialty of the lawyers who are practicing before us and helping us be educated and be better judges.
So for those of you looking for a Switzerland to take refuge in, let me offer the Northern District of California. Invite Judge Illston to correct me. We are a pilot district and have had a pilot program since the inception. And yet our experience has been that very few cases have actually been reassigned or concentrated. I think it's something less than 10 or 12, if I'm not mistaken.
Might as well not have any, really.
Yeah, and part of what explains that is that many judges have volunteered as so-called pilot judges. Those who have not, with maybe one or two exception, continue to enjoy having their fair share of patent cases, and so they're not particularly eager to reassign them upon the direct assignment of the case. And so the practical effect has been pretty much the status quo, I think.
Well, and the other truth in our district is if judges were to reassign the patent cases, the caseload for the patent judges could become unbearable really fast. So it just wouldn't be practical.
So as we elevate Article III, which I think we should, there are some Article III judges that are publicly outspoken in their hatred of patent cases. And that's unfortunate if you practice patent law. And one thing the pilot program does is it might assure practitioners that a judge who really hates patent law has the opportunity to pass it on to someone who likes it.
One of the great benefits of the conference, for those of you who are new, is people get to disagree about things in the academic environment, that it's healthy to have the disagreement aired. So we have time for a question or two if anybody has them. Has one, is brave enough. Mike's right there.
See, there's always a juror with a question.
Okay, so I write patent applications for a living, and I'm wondering, is there one thing that I should be putting into my applications right at the beginning of the process that's going to help the patentee win in your courts?
A real invention. How's that? How's that?
That's good.
You know? Probably the best we can do.
Well, I would suggest more punctuation, personally.
That's when we tried, I think, Judge Illston's first patent case. She arrived on the bench for the pretrial conference, and she said, I have a question. And she said, why are these claims written as one sentence with no punctuation? And everybody looked at each other, we have no clue.
I guess I'd also add that I wouldn't be deterred by the current chaotic state of the law post-Alice, that I think some of the decisions make no sense, especially in the biologic area, and there are just some mistakes being made, I think, in the way some of the decisions are coming out, and I hope that in the time as the process of analysis of what the Supreme Court was trying to say gets refined to something logical, that there will be more certainty. I mean, there are certain decisions, I mean, I guess because I'm off the bench, I can now say, you know, the Ariosa decision left me scratching my head. If I were a district, I would have come out differently on that one. I don't understand. I mean, I think, a misinterpretation, but that's just my view of what the Supreme Court was saying in that area. And sometimes people are painting that brush so broadly that everybody has a different view of what that is, to the point where former Director Kapos has literally, in a speech recently, called for abolishing Section 101 completely because of the chaos that has erupted post-Alice. So I think that you need to take care to understand the fundamentals of what that decision is talking about, but I don't think the fact of one decision or another coming out that may seem aberrant should not deter those who truly have an invention from getting it patented.
So one of my jobs is to keep us on time, and we're at the witching hour. I hope you'll join me in thanking the panel. I think that they've delivered everything that we promised and more. It's all information I would have loved to have 40 years ago when I started practicing, but thank you.